Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of two cases, and the first case are the estates of Buljic, Garcia, Ayala, and Fernandez versus Tyson Foods, Inc. And it looks like everyone's ready. It's my understanding Mr. Yoshimura and Mr. Wolff are going to share time. Is that correct? Okay, you guys are in charge of deciding who goes first, and if one takes up way too much time, darn. So I'll let you guys split the time. Mr. Ulmer, are you ready to proceed? You may begin.
May it please the court, counsel. During the early months of the COVID-19 pandemic, Tyson Foods made fraudulent misrepresentations to employees at its Waterloo, Iowa processing facility. Despite an ever-increasing number of sick workers, Tyson denied that there was COVID-19 at the plant. It told workers that it had been cleared of COVID-19 by county health officials. It prohibited interpreters from communicating with non-English speaking employees about COVID-19, told employees with COVID-19 symptoms to continue to come to work until they had received a positive test, even as some of these workers were so sick they were throwing up on the production lines. All the while, supervisors were placing bets on how many positive COVID-19 cases would result from the outbreak. The end result was the largest workplace outbreak of COVID-19 in the entire country, resulting in the deaths of Ms. Buljic, Mr. Leno, Mr. Ayala, and Mr. Hernandez, among others. There are three underlying issues that are woven throughout the issues presented to this court. The first is whether or not the court is going to continue to adhere to its long line of precedent, allowing notice pleading and adopting notice pleading as the rule in Iowa courts. The second is whether the petition adequately provided fair notice, which is required under the notice pleading statute, to the defendants of the claims against them. And then the third issue, which I think is the real question to be determined today, is whether or not the Workers' Compensation Act legislation, which was originally intended to protect workers, now protects employers and coworkers from intentionally tortious conduct. Here, the intentional tort of fraud. In the year 2000, this court established an exception, or announced, rather, an exception to workers' compensation exclusivity in cases where an employer, who would typically be immune from suit, committed the fraud through an alter ego or commanded or expressly authorized another to commit the fraud. That exception was noted as being accepted, noted by Larson's Workers' Compensation Treatise. It was cited favorably by the court as a rule with which the court agreed. Yes, Your Honor.
Have we ever had a case that's actually found an entity liable under that exception in Nelson?
Not yet, and there's reasons for that. The next case that came up that asserted that exception was the state of Harris versus Papa John's. And in that case, there was no allegation that the employer ever directed, commanded, or authorized the tortious act, the intentional tort in that case, which was an assault, a battery, where a supervisor punched another employee. There was no evidence that that was directed, authorized, or commanded, I suppose, by the employer. Same in Nelson versus Winnebago. In the Nelson case, which sort of initially adopted this theory or idea, it was a case of a person who was at a retirement party. He was taped and bound and carried as a practical joke and dropped and was hurt. He sued Winnebago and coworkers, alleging that the intentional tort did not fall within workers' compensation. But the problem with his allegations in that case is that he never alleged that Winnebago, in fact, directed the supervisor to commit the tort, nor did he allege that Winnebago authorized the supervisor to commit the tort. And so the exception that was announced by Larson wasn't realized, and the court said, acknowledged in its opinion, that there was no allegation in that case that the intentional tort or the tort was commanded or especially authorized by the employer, and so that exception wasn't met. As far as I can tell, this will be the first case where this court has had the opportunity to apply or not this intentional tort exception to workers' comp exclusivity, because this is the only case that I am aware of where there has been a direct allegation that Tyson directed its executive and supervisory employees to make these fraudulent misrepresentations.
Where your argument with respect to employer liability with the statutory text regarding employer immunity, and then respond, if you would, to opposing counsel's argument that you're misreading Nelson, and that's really talking about a more limited fact pattern where the employer is essentially a small shop and the employer's on the floor with his or her coworkers.
Okay, I will try to get to both of those. In terms of the reading of the statute, may I get a drink of water? Just real quick. Sorry, thank you. In terms of the reading of the statute, Your Honor, the Workers' Compensation Act never mentions intentional tort. Not once does it come up. We have a discussion of the legislative history within our briefing where the goal at the time, and the known goal at the time when this was enacted in 1913, was to allow injured workers and to protect injured workers and promote safety for workers in the new sort of industrial era by allowing a remedy, because under typical negligence claims at the time, which was what the workers had available to them, the employers had defenses of contributory negligence, fellow servant rule, and assumption of the risk. And as a result, I think 80% or more of those cases failed when these workers were hurt and bringing the negligence claims against their employers. So as a remedy for negligence, the courts the legislature allowed this bargain to be struck, whereby workers would receive coverage in exchange for not being able to sue their employer or coworkers for negligence. And the reason I keep saying for negligence is because if you continue to read the act, I think it's section 87.21 of the Workers' Compensation Act prescribes what the consequences of opting out of workers' compensation. And that all, again, relates to negligence. The employer will be presumed negligent and will have the burden at that point will shift to the employer to prove that they were not negligent, and they will lose those typical defenses that existed in the past. And if you think about, too, it just...
Nothing in the text of 8520 that specifies or makes any distinction between claims of negligence, gross negligence, willful and wanton conduct, intentional conduct with respect to employers. I understand 8522 deals with employee-type claims, but is there anything textually beyond kind of the theory of the grand bargain and all the legislative history you cite that would get us to where you want to be?
The argument would be, Your Honor, that it's the absence of text. Their intentional tort is not, and negligence is replete throughout the act, never is an intentional tort. And so if the legislature had intended this exclusivity to also cover intentional torts, you would expect to see that language in the act. So it's, Your Honor, an absence of that language that supports that it was not intended, along with the legislative history and the public policy which supported enacting the Workers' Comp Act in the first place. Your Honor, you had also asked if I respond to the question about this is only intended to apply to those situations where it's a owner-operator shop. Well, that's definitely reading something in to the act that's not there. Employer isn't defined as a owner-operator. And so to presume that when Nelson versus Winnebago was being decided, that this court meant the intentional tort exception that it was acknowledging in a suit against Winnebago would only apply to a sole proprietor or sole practitioner is adding something to the act that is not present. And again, it would be counterintuitive to say that a sole proprietor intentional tortfeasor has greater liability than a corporate tortfeasor when that corporate tortfeasor under the rule can be held responsible for directing an intentional tort or expressly authorizing an intentional tort, as opposed to committing it themselves. So I think the rule itself presupposes that it can be applied as against a corporate employer as well as an individual who happens to be an employer. And I think some of the confusion that has come up with respect to the application of Nelson, because I do think there has been confusion in the application of Nelson, is the language from the court that says where the gist of the claim is for physical injury, workers' compensation exclusivity applies. And that has been oft quoted. It was quoted by the court below in this case as one of the reasons why all these claims would fall within the umbrella of the Workers' Compensation Act. But that language came in the context of a second way for an employee to sue their employer, and that is when the act that is being sued for falls outside of the workers' compensation scheme entirely. And so in that case, through creative pleading, the injured worker said, I was falsely imprisoned, which is an intentional tort, but that's aside from the point. But the argument was that is a tort which sometimes can result in damages without a physical injury. And since work comp is looking at physical injuries, I'm out of work comp because my claim can result in damages that aren't physical, and so you should allow me to proceed. And to address that issue, that specific idea of creative pleading, the court said, well, no, if your injury is physical in nature, regardless of how you classify it, you fall within the act. That statement did not erase abrogate the reasoning and the rationale from the same court, the paragraph above, which recognized an exception for intentional torts commanded or expressly authorized by the employer.
And about the COVID Immunity Act?
I can, Your Honor, briefly. I think that, in our brief, we made several arguments. One is that I don't think it's right for review because it hadn't been ruled on by the district court below, but still addressing that anyway. Applying it in this case would be a retrospective application of the law because the rights of our decedents, their families vested prior to this act coming to fruition. There is an express indication that it should be retroactive back to January 1st, but under the Thorpe versus Casey General Stores case and its progeny, where there's a vested right involved, which is the test that Iowa has followed historically. When there's a vested right involved, you can't apply legislation retroactively to strip those rights, even if it were to apply.
Did not involve a public emergency on the scale of this pandemic. Does the legislature have more room to retroactively bar tort claims when it's an emergency of this scale?
It's a slippery slope to say that they do. Because when does it become an emergency and who makes that decision such that now we can make a retroactive application of a law because this is an emergency, and how grave and how great does it have to be? When you're dealing with vested rights, as you are here, I think that the best course would be to have a consistent application of the law that acknowledges vested rights can't be stripped for any reason. And furthermore, should that statute, the Back to Business Act, be applied in this case, there are exceptions in that act for actual malice, for intentional act, and for reckless disregard. So those are factual questions. Was there reckless disregard? Was there actual malice? Was there intent? We, in those issues, would not allow and trump the notice pleading standard to require dismissal. Should the court have even reached it, the decision would have been at that point, well, these are factual issues, or should have been that these are factual issues, and that the petition does allege facts which would support a jury finding of one of those exceptions to the act. I see my time is up. If there are no further questions, I'll try to address more on my rebuttal. Thank you.
Thank you, Your Honor. May it please the court, counsel. This case concerns, as the court knows, 3 tragic deaths in early 2020. The allegation is that the employees contracted the disease at their place of employment, and it has been admitted that all of the 15 individually named defendants in this case were acting at all times in the course and scope of their employment. Indeed, in Mr. Ullman's summation of the relevant facts in this case just now, he explained that the employer, the company, took actions and made statements, none of the individuals. These are straightforward workplace injury claims. They belong before the DWC. They are in the exclusive province of the division. And the legislature has made the judgment that the courts are divested of jurisdiction over these claims, which is why the district court dismissed them. Nevertheless, the plaintiff here has engaged in some creative pleading of their own and tried to, through some gamesmanship, keep these claims in the courts. But that gamesmanship has been expressly rejected by this court. In fact, just last year in the McCoy case, Justice Oxley wrote that plaintiffs cannot, quote, avoid the statutory processes for seeking redress, i.e. the Workers' Compensation Act, by, quote, manipulating common law theories in order to reach the jury. And that's exactly what we have in this case. Although it wasn't discussed in much depth, Mr. Ullman mentioned that he continues to argue that the standard of review here should be notice pleading, even though the matter at hand is subject matter jurisdiction. Notice pleading, of course, has to do with the
I have to say I don't really buy that. The issue is to the extent that the plaintiffs are suing co-employees of the decedents under the gross negligence exception, isn't just the issue whether they've stated a claim, and we do have notice pleading here in Iowa?
Below, in the district court, we actually had 2 alternative bases to move to dismiss, and one of them was under Rule 1F, which is that there's been the failure to state a substantive claim, and that, of course, notice pleading would apply to that. However, the case law is clear that when the motion is based on a lack of jurisdiction, be that subject matter or personal jurisdiction, that the district court has more powers to determine the issue immediately.
You know, talk about, you know, gamesmanship. That sounds a little like gamesmanship to me. I mean, the issue is, isn't really the bottom line, have they sufficiently alleged gross negligence by one or more co-employees so as to fall within, so as to have a valid claim under Iowa law that's not barred by workers' comp?
So the analysis done by the district court revealed that the correct standard is to, of course, presume the well-pleaded facts as true, and then to the extent any other facts are needed, they can be developed and found by the court in order to make a determination. What the district court found was that assuming all of these well-pleaded facts are true, there is no possibility for the court to maintain jurisdiction over these claims. And so the notice pleading standard does not apply because when you're talking about stating a claim, the question is whether the opposing party has fair notice of the claim's general nature. But when it comes to the court's authority to act, we cannot merely give the court fair notice of the general nature of its hypothetical jurisdiction. In the Mormon case in 2018, this court directed the district courts to actively manage the disposition of preliminary questions regarding subject matter jurisdiction based on the framing of the issues as they are in that case. And that's what the court did here.
With respect to subject matter jurisdiction, the statute gives us jurisdiction over claims of gross negligence against coworkers. And so we don't need to doesn't that just get us straight to notice pleading then?
It does not if the pleading itself does not state any possible claim that would allow the court to exercise jurisdiction to develop a factual record. But to the extent there's any question about that, the court is empowered to engage in limited discovery or fact-finding in order to answer that question. And what the court rightly determined in this case is that none of that is necessary because the gist of the claim is one for workplace injury. And so that's why you still presume the well-pleaded facts to be true, but if anything more is needed for the court to assure itself of its own jurisdiction to proceed, it's empowered to take those steps.
Bar the plaintiffs have to get over here. And the district court talked about this sort of group pleading and how that was a problem here. I struggle to see that. I mean, we have group pleading constantly. And I think even in the district court, counsel referred to their clients as supervisory defendants. And so, I mean, isn't this kind of, I don't know, being a little nitpicky, especially when the bar is as low as it is?
Necessarily agree that the bar is that low because what the plaintiffs are asking you to do is set the bar low by establishing notice pleading for questions of jurisdiction. But that's actually not the standard that we're applying here.
On that point, does your client lose?
Not. Even if notice pleading applies, and this court is empowered to affirm on an alternative basis that they have failed to state a claim on which relief can be granted, which is the case here. Even under notice pleading standards, the plaintiff's claims need to be dismissed, especially as against the individuals. However, the court below rightly found that under any reading of the facts as alleged, they do not satisfy the exception in the statute, which, as this court has stated, is actually a high bar, not a low bar. So there's already some tension if this court intends to apply notice pleading for an exception in the statute that is rarely, and in fact only in one case as cited by the plaintiffs, applied.
What about plaintiff's argument that many of the cases that deal with gross negligence are resolved at summary judgment or directed verdict stage? And here, I mean, under our pleading standards, I would think if the plaintiff just said, I'm asserting a claim for gross negligence, more to come, that's kind of, that's where our pleading standard law is, really.
On a motion under Rule 1F under notice pleading, we would agree with that. The case law on subject matter jurisdiction is quite different, which says that at any point in the proceedings where...
But let's assume that we disagree that there's a different standard for motions to dismiss on jurisdictional grounds. If we're just looking at a 1F motion, failure to state a claim under our notice pleading standards, is that enough in this case? And I understand you have alternative arguments, but...
They will, however, in the interest of time, defer that argument to Mr. Wolff, and it has to do with the underlying elements of the claims, which, of course, we've briefed up in our papers. Thank you.
Going to tag me? Sure, I'll take that. May it please the court, Eric Wolff for the employer and the executive defendants and Mary Jones. So what I heard was there's a long line of precedent that said they get notice pleading. Okay, that's not true. Like, you actually would be saying something new if you say it's notice pleading. Sounds like some of you think it should be notice pleading. On the question you just asked, though, your standard for gross negligence is really strict. And those three elements of actual knowledge, of a probable injury, and then conscious disregard, like that's pretty strict. And I think you do need to see that in the complaint. Like, even if it's notice pleading.
And the standard for proving gross negligence are very strict. My question is at the pleading stage, just pleading gross negligence, is that enough if we don't agree with your position on the jurisdictional pleading standard?
I mean, it's up to you all how open-ended you wish notice pleading to be. I think there are very good reasons, and you've already given some of them, why you shouldn't just let conclusory allegations of gross negligence be enough. And that the reasons you gave were, we have cases that have gone all the way to the jury. Well, and then we learned that they should have gone to workers' comp. I mean, that is not how this is supposed to work. I mean, the point of workers' comp, the trade-off, is you don't have to prove liability with some exceptions, but you get prompt payment. Going all the way to a trial because we had notice pleading at the beginning and we allowed all these conclusory allegations, group pled, not even attempting to show how any defendant had actual knowledge, not even attempting to explain how anyone thought it was probable that the plaintiff would be injured. I mean, your case law on liability is actually really good. Henrik and Swanson together in 1989 make it very clear. In one situation, you knew exactly that Swanson had a defective suit, his supervisor knew that, and that it was a very dangerous chemical that was gonna burn him, and if it burns him, he's gonna go to the emergency room, okay, that's gross negligence.
Is that were decided after pleading. I mean, do you have any of our cases where we've kicked out the gross negligence at the pleading phase?
Once you tell the employers out there that that's the kind of standard, so Henrik says, mere actuarial risk is not enough. Okay, that that some people might get COVID or that some people might get cut on the machines, that's not enough. Once I know that, you shouldn't be able to state a claim when just by pleading with something that looks like actuarial risk because you all have changed the liability standard.
Then why would not we let the plaintiff then have discovery to learn that? How are they supposed to know that other than to be able to plead it? They have to have some kind of basis.
In this instance, they've had several years. They've actually deposed some of these folks through the workers' comp proceedings. I mean, it's not like they just showed up in court a month ago and I have no idea, how I would ever learn this stuff. They've had several years and several complaints and discovery in the workers' comp system. So there may be some cases that are as you described. This is not one of them.
Standard that we apply when we're looking at a pleading.
True, although I think your own case law on what meets the exception, the factors for the exception, all should be part of what you apply to that complaint. And if you look at the complaint, I mean, the complaint says fraud, right? But the fraud it's just this broad side, Tyson knew and said otherwise. That's not even fraud. Fraud has multiple elements, including a particular person's reliance upon it. I mean, it's up to you all if notice pleading is just going to be a complete drive-by, like you suggested, this sort of, hey, if I just say it's gross negligence and we'll tell you more later. If that's going to be enough, then we will have more cases where it goes all the way to summary judgment, goes to trial, and then we find out we're in the wrong place. I don't think that's a good system. I don't know why you would want that system.
Claims against the individuals be litigated in the work comp proceeding?
Well, I think there's really not much to litigate because they say it's a workplace injury. There's an issue of did you get COVID in the workplace versus at your church?
Involves the liability of the employer under the workers' compensation statute, right?
In some
about here are claims against individual defendants that would not be subject to workers' compensation liability. So I don't understand why you keep saying it's just the wrong place. It's not the wrong place. It's about whether or not there's a claim, right?
And I actually think your case law is really good on this sort of gist of the claim. The gist of the claim is the personal injury. You're going to get compensation for that in workers' comp if it's a workplace injury. Now, there's some issue of did you get it at work or did you get COVID at your church or the grocery store or something like that? But other than that, if it's a workplace injury, you get compensated. And at that point, it doesn't matter. And what we have here, and if you think about the gist of the claim, what we have here is essentially what this court talked about in Henrik. The complaint, and from the very beginning, the complaint is about Tyson. The complaint is about Tyson's policies. They should have been better. There should have been more protective equipment. Should have been different workplace rules, things like that. This court pretty clear in Henrik that this idea that, you could have made it safer, that you knew that there would be some injuries, that's a claim against the employer, and that people who are just carrying out that policy are not grossly negligent. They're just carrying out the policy. Gross negligence is essentially going rogue or doing something that's so dangerous, like in Swanson, where on that shift, the supervisor knows that there's a hole in the suit and that he's had water come through the suit. Like, he's going to get the chemical on him. And that is a very different situation, as we learn in Henrik, from how you let people operate these machines. It could be different. Maybe they shouldn't wear gloves, but you let them wear gloves. That really is what we have here. Like that.
COVID immunity, the back to business statute?
We've treated it as just sort of confirming everything we're saying about how this is supposed to work. And it does have that section at the end that says it's not trying to alter any workers' compensation rules. I mean, the retroactivity thing, I don't understand. They only raised that in their reply brief because these are just rules of decision. Like if you all handed down a new decision about some aspect of tort liability, we would apply it to pending cases. The same goes for statutes. Like you just apply the rules to the pending cases. It's not opening up a judgment. It's not taking away something they've won.
Distinguish the Thorpe case then.
I can be like my co-counsel, but I see I'm out of time and I don't have any thoughts on the Thorpe case.
Go ahead.
Good. No, I honestly, I don't really have an answer to that. I mean, and that's just sheerly a matter of preparation. We've treated the Back to Business Act as I mean, it's on page 70 of our brief, like it's just sort of echoing everything we've said before that. And lots of states have passed those. I don't think there's any significant separation of powers or retroactivity problem.
Is he done? Okay. All right. Thank you.
Thank you. I want to start with the idea that there's an increased pleading standard associated with subject matter jurisdiction cases. I think this court has recently determined that there is not. In the case Terrace Hill Society Foundation versus Terrace Hill Commission, which was decided this summer and then amended in July, that case procedurally was positioned on a motion to dismiss for lack of subject matter jurisdiction. And in that case, the court reaffirmed the application of notice pleading. So I don't know what cases they're talking about when they say there are cases that say that when you're talking about a lack of jurisdiction, there's something more than notice pleading, because I'm not aware of those. I am aware of a case where the legislature enacted specific requirements in asserting sovereign immunity that must be pled. And this court said, well, okay, if the legislature is going to say specifically that people need to plead X, Y, and Z in order to obtain sovereign immunity, I think that is, I'm going to say it wrong, the Nahas case is what's coming to mind, then those are what you have to do. That is distinct from the situation that we're dealing with in workers' compensation. And so I was unable to find any cases that made a distinction on subject matter jurisdiction. In fact, the court has been consistent here. With respect to what is required and what is pled, even though notice pleading is what's required, even though the ultimate issue, ultimate facts need not be pled under notice pleading, the petitioner's second amended petition in this case pled facts supporting each element of fraud and facts supporting each element of gross negligence as adopted by Thompson versus Boakinder announced. The knowledge of the peril, knowledge of injury was probable, and the conscious failure to avoid the peril. So even though that was not required, those exist in this case. Those allegations exist within the petition. And so under any pleading standard, this petition should have made it past the motion to dismiss stage. There is a practical situation. There's two, you're weighing in the balance here this idea between having litigation proceed and allowing cases to be decided on their true merits. Because there are situations, including where the plaintiffs are not going to have access to all of the facts at the outset. They are only going to obtain access to those facts through discovery. And if through discovery, access to those facts is insufficient to support the claims, the defendants have another tool at their disposal, and that is a motion for summary judgment, where the plaintiff needs to come forth with admissible evidence that will support his or her cause of action. So this isn't a situation where if we don't get rid of notice pleading, we're going to have all of these cases and all of these trials, and that's a waste of everybody's time.
Ask you a question about the immunity legislation again, and I know the Thorpe case says what it does. I guess I'm not sure that's right. If you haven't filed a lawsuit, if there's just a situation out there and the legislature changes the law, what property right are they taking away from you? It's not something that strikes me as vested at that point in time with no lawsuit.
Of when does it vest? Your right to file a suit, your right to bring a claim has been said by Thorpe to vest not when you actually file it, but when all of the elements are there and you have your claim, it's vested and you can do it. If you were playing devil's advocate, if you were to say, well, your rights don't vest until you file something, how does that affect the statute of limitations? You could say, well, why did I have to follow a 2-year statute of limitations? I don't have a right that's vested until I file my complaint. And so, I mean, it seems to me that would create problems. There are cases, there are other jurisdictions that have evaluated COVID immunity statutes. Florida, for example, we cited some of those in our brief. In Florida, it follows a vested rights analysis and upheld that the statute could not be applied retroactively. And lastly, we brought this up in our reply because we were replying to the argument being brought up by them in their response brief. It wasn't something that was fully pled and fully briefed, Your Honor. So I'm out of time.
Can I ask a follow-up, Chief? Understanding about the timing of this. When was the petition filed in this case?
I have that. I think there was an August 2020 petition.
I had June 25th, 2020. Is that incorrect?
Yes, one was in June, Your Honor. So we have two cases that are consolidated for purposes of this appeal. The Buljic case, which has 3 cases, and then the next case was the Fernandez case. And one was filed in June, and the second was in August, and I don't have in my notes specifically which one was which.
It was passed in June 18th of that year.
Effective July 1st, and then was said to be retroactive to January 1st.
These were on file before the statute was effective. Is that the situation? Okay.
Thank you.
Thank you. The case with the Plaintiff Estates versus Tyson Foods is hereby submitted, and the court will pause for a few minutes here to prepare for the State versus Dorsey.